The process server was still fumbling with the clasp on his manila envelope when my son's truck swung into the far end of the driveway and stopped at an angle that blocked the gate. He didn't cut the engine for a full 30 seconds. He just sat behind the wheel with the window rolled down, elbow hanging out, watching me the way a man watches something he already considers his property. My daughter-in-law was out of the passenger side before the truck fully stopped, phone raised, recording. "Morning, Grady," my son called across the yard. His voice came out easy and loose, the way you talk when you're already certain of the outcome. He was not addressing me the way a man addresses his father. He was performing. "Go ahead and take those papers. It's better this way." I looked at the process server. He was young, maybe 28, with the expression of a man who had been handed a job without being fully briefed on what it was. He extended a thick legal envelope toward me with both hands, slightly bent under its own weight. "Sir, I'm sorry to be here like this." He would not quite meet my eyes. "This is a notice of a competency hearing filed in Sevier County Circuit Court. The petitioner is requesting judicial review of your capacity to manage your personal and financial affairs." I took the envelope. I did not tear it open. I did not raise my voice or step back from the door. I adjusted my reading glasses, studied the official seal, printed across the front for a moment, and then I looked up at the young man and asked him one straightforward question. His face went the color of old chalk. "My name is Grady Tolliver. I am 64 years old. For 31 years, I worked as a licensed structural engineer on federal highway and bridge infrastructure projects across the southeastern United States. My job, from the first day to the last, was the same. Find the failure point before it finds you. Understand how a structure is built. Understand what it's designed to carry, and identify precisely where and how it will break under load. I am very good at that. Welcome to Molten Vengeance. If you've landed here, you already know the kind of stories we tell, about ordinary people who got pushed to the edge and chose to push back. Stay close. What happened on that driveway is the end of the story. The beginning is considerably uglier. Before we go any further, I want to ask you something. If someone in your own family quietly began building a legal case to strip you of your rights and your property, someone you had raised and loved and sacrificed for, would you confront them the moment you found out? Or would you keep that knowledge to yourself, let them keep believing they had you fooled, and use that window to construct something they could not walk away from? Drop your answer in the comments. I read every one of them. One note before we continue. Certain details here have been adjusted for privacy and clarity. The truth at the center of it has not been touched. My late wife's name was Paulette. She had the kind of patience that was almost supernatural, and the kind of stubbornness that ran in a direct line back through her people, as far as anyone could trace. We spent 36 years together in the farmhouse on Clover Ridge Road, 12 acres of East Tennessee hill country that her grandfather had cleared with a mule and a borrowed blade, and her father had built on with his own 2 hands. When Paulette was dying, when we were in that hospital room in October, with the window showing a sky that had gone dark early, she held my hand and she said, "Don't let it go to strangers, Grady. That land is all of us." Those were not her last words to me, but they were the ones I walked out of that room carrying, and I haven't set them down since. She's been gone 4 years now. My son, Rhett, is 39. He runs a landscaping operation out of Maryville that has done reasonably well at times and considerably less well at others. He married Cassidy about 6 years ago. She's a licensed practical nurse, works at a regional medical facility outside Knoxville. I want to say this clearly, because it matters to the story. I did not dislike my daughter-in-law before any of this happened. She was attentive to Rhett in ways that seemed genuine. She cried at Paulette's funeral, and I believe those tears were real. She called me Dad inside the first 2 years of their marriage, and I didn't correct her. The version of Cassidy I thought I knew was someone I had genuine respect for, which is precisely what made what she did so devastating to absorb. It began on a Thursday evening in early August. I remember because I had spent the afternoon patching fence line on the south end of the property, the long stretch that runs parallel to the creek, and I was sitting on the front porch, cleaning mud off my work boots when Rhett's truck turned in without calling ahead. That alone wasn't unusual. What was unusual was that both of them were in the cab, and Cassidy was crying before they reached the steps. I brought them inside. I put the kettle on and found some cups. I sat across from my son at the same kitchen table where Paulette and I had sat for 1,000 Sunday mornings, and I listened. Rhett laid it out carefully. He said a commercial client was threatening to sue his landscaping company over a grading job that had allegedly damaged an irrigation system. He said the potential liability exposure was serious. The business accounts were already thin after a slow summer, and his accountant had told him the most efficient way to protect his personal and family assets was to establish a temporary financial power of attorney with a trusted family member acting as his designated agent, meaning me designating him. He said it was a standard protective measure. He said it was temporary. Cassidy reached across the table and put her cold hand over mine. "Dad," she said, her voice soft with just the right amount of fracture in it, "we wouldn't be here if there was any other option. You know us. We just need this arrangement in place until the lawsuit threat clears. Rhett's attorney says it could be resolved in a few weeks." I asked several questions. Rhett had smooth answers for most of them, the kind of answers that don't leave much surface area to press into. I told them to have his attorney send me something in writing, and I would look it over. They left before 9. I stood at the kitchen window and watched the taillights of Rhett's truck disappear down the end of Clover Ridge Road, and I felt something move through me, faint but precise, like a vibration in a structural member that hasn't cracked yet but is working toward it. I told myself I was reading too much into a difficult conversation, that Rhett was my son, that I had coached his baseball teams and driven him to every practice for 3 straight years and lent him money twice without once asking for it back. I almost talked myself all the way into letting it go. 2 weeks later, Cassidy came by on a Tuesday afternoon, alone, on the pretense of being in the area. She brought a casserole dish. She chatted easily while I found a spot for it in the refrigerator. And then, as she was pulling on her jacket to leave, she mentioned, almost as an afterthought, that she had been noticing some signs of forgetfulness in me lately. "Little things," she said. "Nothing alarming." She framed it with the measured gentleness that nurses learn for delivering difficult information. She said she thought it was worth paying attention to. I looked at her and told her my memory was fine. She smiled and patted my arm and said, of course, she was probably just being overprotective. Then she left. I stood in my kitchen for a long time after I heard her car pull off the gravel and onto the road. A structural engineer does not dismiss anomalous readings. Cassidy had not been making conversation. She had been making a record. The word choice, the timing, the careful softness. It was too deliberate to be casual. She had documented something, either in her phone or in her own memory, that she intended to use. I did not call Rhett. I did not confront either of them. I drove into Knoxville the following morning and retained an estate and elder law attorney named Denton Kincaid. I had worked with his firm on a contract review 11 years earlier and trusted his precision. I sat down in his office and told him everything I had observed in order without editorializing. When I finished, he was quiet for a moment, and then he said the pattern I was describing, manufactured financial distress, request for financial control, sudden documentation of cognitive concerns, was one of the most common setups he encountered in elder financial exploitation cases. He told me we needed to move carefully and document everything on our end. I left his office with a referral to a private investigator and one additional piece of information that Kincaid volunteered near the end of our meeting. Information that he said I should keep very close to myself for the time being. We'll come back to that. That same week I drove to the Sevier County Courthouse and pulled the complete public record on my 12 acres. I wanted to see everything currently filed against the parcel. And there, recorded in the deed books from 6 years prior, was a document I had partially let drift from the front of my mind in the weight of the years since Paulette's death. In the months after her diagnosis, when we still believed she might have time, we had sat down with an estate planning attorney in Gatlinburg and worked through what we most needed to protect. Paulette had been immovable on one point. The land could never be broken apart and sold for commercial development. Her grandfather had worked that ground. Her father had built the house by hand. The thought of it becoming a storage facility or a retail lot was something she said she could not die peacefully alongside. So we had enrolled the 12 acres in the USDA Natural Resources Conservation Service Agricultural Conservation Easement Program. Under the terms of that agreement, the property was permanently restricted from commercial development, subdivision for non-agricultural purposes, or any use inconsistent with the land's residential and agricultural character. The easement ran with the land in perpetuity. It was recorded in the county deed books and could not be removed by any subsequent owner or any legal instrument short of federal action. Standing at the records counter in that courthouse, I felt the entire architecture of what Rhett and Cassidy were building come into focus in a single moment. They had found a buyer, a developer, someone willing to pay serious money for 12 acres of East Tennessee land they could put to commercial use. But to complete the transaction, they needed legal control over me and clear title over the property. To get control, they needed a court to declare me mentally incompetent and appoint them as my guardians. And to get the court to do that, they needed medical documentation. Documentation that Cassidy was uniquely positioned to produce. The private investigator confirmed the rest within the week. Rhett and Cassidy had a signed letter of intent with a commercial developer out of Nashville who intended to build a self-storage complex on the acreage. The purchase price was $1.6 million. The transaction was contingent on unencumbered title and clear ownership transfer. $1.6 million secured by the ground where Paulette had planted her first garden. By the oak tree her father had put in as a sapling before Rhett was born. I drove home and sat in Paulette's reading chair by the front window and let the full weight of it land without trying to move away from it. I gave myself that much. I let it be as bad as it was for as long as it needed to be. Then I called Denton Kincaid and told him it was time to build the counter. The performance I put on over the following weeks was, if I am honest, some of the finest work of my life. It began small and escalated with careful, deliberate precision, the way a well-designed structure reveals its capacity gradually under increasing load. When Rhett stopped by the following Saturday, I forgot mid-sentence what I had just been saying, twice, in the span of 10 minutes. I stood in front of the coffee maker for a full minute as though I had never encountered the machine before. I told him a story about a trip Paulette, and I had taken to Gatlinburg in the early 2000s, and then told it again 40 minutes later with different details, watching his face as I did. What I saw in his eyes was not concern, it was relief. When Cassidy came the following visit, I left water boiling on the stove too long. I misplaced my wallet and let her help me look for it. Let her find it in the kitchen drawer where I had placed it. Watched her photograph it with her phone before handing it back. She began bringing reading material on subsequent visits, pamphlets about memory care options and assisted living facilities in the Knoxville metro area, left on my coffee table as though by accident. On one visit, she produced a form she said was from my insurance provider, asking me to sign. I signed it slowly, with my hand trembling just enough. I had read the form the evening before she brought it. It was what she said it was, nothing more. But I needed her to believe the trembling hand was real. By mid-September, both of them had stopped choosing their words carefully around me. Rhett spoke to me in the slowed, elevated voice that people use when they are no longer certain you can track a normal conversation. Cassidy stopped maintaining any pretense of visiting for social reasons. She would arrive, spend 45 minutes observing and documenting, and leave. She had begun using the word placement in my presence, as in, when we start looking at placement options, without any particular care about whether I registered what she meant. They had stopped thinking of me as an opponent. They thought I was fading on schedule. Meanwhile, Denton Kincaid had obtained a copy of the psychiatric evaluation that had been submitted with the competency petition, a formal clinical assessment purporting to document my deteriorating cognitive function. He sent it to a forensic document analyst and a board-certified neuropsychologist for independent review. The report bore the signature of a licensed clinical psychologist in Knoxville with a legitimate practice and an established professional reputation. The analyst's findings came back within 10 days and were unambiguous. The clinical observations embedded in the document, the behavioral descriptions, the administered test scores, the diagnostic language, none of it was consistent with that psychologist's documented methodology and professional vocabulary. Formatting irregularities suggested the document had been constructed in parts and assembled. Most critically, the psychologist had no record of any appointment, evaluation, or contact with me of any kind. She had never met me. The report was fabricated. It had been built by someone with working familiarity with medical documentation and clinical assessment language. Someone who knew how those reports were structured and what they needed to contain to be convincing to a judge who was not a clinician. Cassidy had constructed it. She had not forged the psychologist's signature in a crude sense. She had built the interior of the document, the observations, the findings, the diagnostic conclusions, and attached a real physician's identifying information to give it standing. That is federal healthcare fraud. That is criminal identity fraud. That is the filing of a false instrument in a state court proceeding. Depending on how aggressively a prosecutor chose to pursue it, it was potentially the end of everything she had built for herself. Denton told me to do nothing visible. Let them proceed. Let the papers get served. Let them arrive on the morning of the service with their confidence running at full capacity. Let them believe they were 30 minutes away from owning everything. I was already awake well before sunrise on the morning the process server came. I sat at the kitchen table with my coffee and watched the eastern ridgeline begin to separate from the sky in that slow, gray way it does in late November. The process server came up the walk at 7:42. Rhett's truck turned in from the road 30 seconds behind him, timed precisely, because my son wanted to be present at the moment I received what he believed would be the final document of my independence. Cassidy was out of the truck with her phone up before her shoes were properly on the gravel. I stepped out onto the porch. I took the envelope. I studied the seal. I looked up at the process server, and I told him that the psychiatric evaluation report filed in support of this petition had been fabricated by a licensed practical nurse operating well outside the legal scope of her credentials. I told him that the forensic documentation, confirming that had already been transmitted to the Tennessee Bureau of Investigation and to the State Medical Licensing Board. I told him that the document he was holding was the instrument of a fraud upon the court, and that I was telling him this directly so it would be on record, that he had been informed before he left my property. The silence that followed was absolute. Then I turned to my son. I told him the 12 acres on Clover Ridge Road had carried a USDA agricultural conservation easement since the year his mother was still fighting for her life. I told him it was recorded at the Sevier County Courthouse. I told him that a storage facility, a strip mall, a parking lot, or any other commercial structure could not be built on that land under any legal instrument, now or ever. I told him his Nashville developer's letter of intent was worthless paper, and his $1.6 million transaction had never been a real transaction. The land was never yours to sell, I said. I was never incompetent. And your wife committed federal health care fraud to try to convince a court otherwise. Cassidy lowered her phone. Her arm came down slowly, the way something lowers when the strength has gone out of it. Denton Kincaid's car came up the drive at a steady pace and stopped behind Rhett's truck. He stepped out in his gray suit and nodded to me, then turned his full attention toward my son. The TBI agents arrived 11 minutes later, 2 vehicles, the kind of arrival that settles, once and for all, who is in control of a situation. I watched from the porch. Cassidy held herself together longer than Rhett did. She had a nurse's discipline about her reactions. But when the lead agent read aloud from the charging document, fabrication of medical records, fraud upon the court, false impersonation of a licensed healthcare provider in a legal proceeding, filing false instruments in support of a fraudulent guardianship petition, she put her hand out and found the side of Rhett's truck and held on. Rhett was crying before they reached him. Quietly, with his face turned toward the ground, the way a person cries when they understand the full weight of what they've done, and have nothing prepared for this version of the ending. I did not go to him. I want to be precise about that, because some people will assume this story requires that I stopped loving my son somewhere in the middle of it. I did not. I love him in the way that is built into the structure of a person and does not get removed. The love was present on that driveway. It simply was not in charge. What Rhett and Cassidy had carried out was not a moment of desperation. It was months of construction. They had researched the Tennessee guardianship statutes, recruited someone to provide a fraudulent clinical document, coordinated with a commercial developer, and spent weeks visiting me in my own home to manufacture evidence of a decline that did not exist. They had done all of that while calling me Dad and eating at my table. Cassidy placed her hands on the hood of the truck before the agent asked her to. She had enough left in her to understand that cooperation was the only asset she still held. My son did not look at me as they walked him to the car. I was grateful for that. I don't know what I would have done with the look. I stood on the porch of the house that Paulette's people built, on the land that is permanently and legally ours, in the way that no forged document and no corrupt petition can ever reach, and I watched the cars back down the driveway and turn onto Clover Ridge Road. Denton came and stood beside me. He was quiet for a minute, which is one of the things I trust about him. Then he said the conservation easement was clean and nothing would touch the property. I know, I said. He said the Nashville developer had withdrawn his letter of intent that morning. His attorneys had called at 6:15. I know that too. He nodded. What do you want to do today? The November sky had opened up by then. The ridge was fully lit, the kind of clear blue that only arrives after a hard frost, the kind of morning Paulette would have claimed for herself without apology. I told him I was going to finish fixing the fence line on the south end of the property, the part along the creek that had been waiting on me since August. Some structures are built to outlast everything that gets thrown at them. You just have to know what you're working with, and you have to know it before the pressure arrives. That's the whole lesson, right there. That's always been the whole lesson. I got my tools and went to work.